So welcome everyone to the Berkeley Law IP and Tech Month for 2024. We have an interesting program that we've been pioneering here. You often get patent law, year in review, kind of the review of all of the cases. But in the world of litigation, there's a whole lot more than just the nitty-gritty coming out of the Federal Circuit. So, with the help of Goodwin and Brett and Andy, we have pioneered this kind of procedural and IP litigation year in review to go through what you can expect and what's changed in patent litigation. So this is a program near and dear to my heart, kind of keeps me tied to my roots. And so I'm really thrilled that once again, Goodwin has volunteered some time to put something new together, because this is not something you can just pull off the shelf. So let me introduce to you the two presenters for today. We have Brett Schumann and Andy Ong. They are partners at Goodwin, patent litigators, trade secret litigators, just all around IP litigators. So they'll bring to you a heavy dose of the practical, what's really going on, what you'll really see, and how things can go wrong outside of the black letter law. So with that, I want to thank both of you. Berkeley wants to thank both of you, and I will get out of the way and turn it over to you. So Brett, I think you were going to kick it off.
Great. Thanks very much, Wayne. And we are thrilled to be back. Andy and I have done this program before. We really enjoy it. It gives us a chance to reread, or in some instances read, for the first time, some of the biggest IP decisions of 2024. We're recording this on November 19th, 2024. With a little over a month left to go, there may be some additional decisions coming before the end of the year, but we have compiled what we think are the most significant decisions through the first 11 and a half months of 2024. So without further ado, Andy, why don't we go to the next slide and I'll kick us off. So we're going to start with a patent case called LKQ Corp versus GM Global Tech Operations, Inc. This is a Federal Circuit case from May of this year, an en banc decision. And before I go into the case and the significance of it, it's worth pointing out that so far in 2024, the United States Supreme Court has not decided any patent cases. Almost by definition, any case from the U.S. Supreme Court is significant in a year in review like this, but we haven't had a patent law case from the U.S. Supreme Court. So when it comes to patent law, we're going to be discussing Federal Circuit cases. We do have in the presentation a U.S. Supreme Court case on trademark law and a U.S. Supreme Court case on copyright law. So we start with design patents. And in this en banc decision written for the court by Judge Stoll, the Federal Circuit changed the test for evaluating whether design patents are obvious or not. So this case involves design patents. We don't see as much litigation around design patents as we do around utility patents, but we do see some. And 17 years after the U.S. Supreme Court's KSR decision, which changed the standard for assessing obviousness with utility patents, in 2024, the full Federal Circuit came around to assessing whether KSR requires a change in assessing obviousness for design patents. So in this case, which involved a design patent for a bumper on a car, GM had a design patent, and LKQ filed a petition for inter partes review, IPR, at the PTO, challenging GM's design patent as obvious. And LKQ also argued that the Rosen-Durling test of non-obviousness should be overturned because it's similar to the former test, the teaching suggestion motivation test, the so-called TSM test, for assessing non-obviousness of utility patents, and that's what was rejected by the Supreme Court in KSR. So these are the two tests, Rosen and Durling on the left, which is, as a result of this LKQ decision, no longer the law. Under this test, it was pretty hard to invalidate a design patent on obviousness grounds. You had to meet two steps. The first step is you had to identify a piece of prior art so similar to the design patent at issue that it was basically the same as the claimed design. And under this now discarded test, that was called the primary reference. If you didn't have a primary reference that was basically the same as the patent, the inquiry was at an end. If you did have a primary reference that was that similar, you then moved to the second step, which was if a primary reference is found, then secondary references may be used to bridge that gap between the primary reference and the patent. But the secondary reference must be so related to the primary reference that the appearance of the features in one would suggest the application of those features to the other. That was the prior test. It was very hard to meet. That is no longer the law. In LKQ, the Federal Circuit adopted the Graham test, which is the test used for utility patents and now for design patents as well. It's a four-factor test of non-obviousness, or if you're the challenger, obviousness, for utility patents, now for design patents. You look at the scope and the content of the prior art. You look at the differences in the prior art and the claimed design. You consider the level of ordinary skill in the art at the time of the invention. And then, if applicable, and they aren't always applicable, you can consider what's called secondary considerations of non-obviousness, things like commercial success, whether the patent solves a long-felt but unresolved need, and the failure of others. So this is now the test for both utility and design patents on obviousness. As I was mentioning on the left-hand side here, the court's ruling, en banc court's ruling, was to overrule the Rosen and Darling test and replace it with the Graham test. And the court's reasoning was KSR, a 2007 decision from the U.S. Supreme Court, which dealt with utility patents and rejected. It wasn't called Rosen and Darling, but it was the TSM test. Rejected that sort of more rigid test. In 2007, the Federal Circuit held here that also compelled tossing out the Rosen and Darling test. So what's the likely impact? Well, as we say here on the right-hand side, the Graham test will likely make it harder to get and easier to challenge design patents because it is more flexible than the old Rosen and Darling test, and it allows for a much broader consideration of the prior art, and that was exactly the point in KSR. So with that, I think we're done discussing LKQ, and Andy, I'm going to turn it over to you for our next case.
Thanks, Brett. So the next case is Amarin Pharma Inc. versus Hikma Pharmaceuticals USA Inc. And this was a dispute between a brand and a generic drug and relating to what is the proper standard to apply in this specific context regarding induced infringement. And this is a Federal Circuit case. So the background is that Amarin sells a drug called Vascepa. Originally, it was FDA approved only for one specific purpose, which is the treatment of severe hypertriglyceridemia. And so the original drug was marketed with a limitation of use specific to that purpose number one. The FDA later approved the drug to also for use in lowering triglyceride levels in patients' blood. When it was only the first approved treatment under the FDA. Hikma received approval from the FDA to sell a generic of Vascepa for that same purpose. But later, when the FDA approved the second purpose of lowering triglyceride levels, Hikma sort of removed some of the language about the original limitation of use from its own label, and more broadly marketed its generic as a generic of Vascepa without mentioning specifically the sole use that it was permitted under the FDA approval for the generic. Amarin brought a lawsuit against Hikma for patent infringement relating to the second use, and argued that the drug's skinny label, which was not limited to the specific use of number one, combined with the public statements that Hikma made, again, not focusing on the specific use, but more broadly claiming that its drug was a generic Vascepa, induced infringement of patents listed in the Orange Book. And the Orange Book is a common term used for ANDA litigation. The district court granted the district court granted Hikma's motion to dismiss. And what the court did there was it looked specifically at first just the label, whether that in isolation would induce infringement. And then it looked specifically at the public statements that Hikma made and determined whether that could plausibly induce infringement. And the court in Delaware determined that each of those in isolation was insufficient as a matter of law to proceed in the case. And Amarin appealed to the Federal Circuit. The Federal Circuit the Federal Circuit reversed the dismissal of the complaint, finding that the allegations outlined in the complaint at least plausibly stated a claim for induced infringement. The court noted this was sort of a unique case because it's not a traditional ANDA case in which the patent owner seeks to establish that if a generic drug is put on the market, it would infringe the asserted patent. As I noted earlier, Hikma already received ANDA approval for the first limited use, so that wasn't an issue here. And it's not a Section 8 case, which is also under ANDA, in which the patent owner's claims rest solely on allegations that the generic manufacturer's label, called a skinny label, is not skinny enough, such that the label alone would induce infringement. Instead, the Federal Circuit sort of applied its broader induced infringement standard, which is that you look at the totality of the allegations as a whole, not piecemeal, not each statement in isolation, to determine whether inducement was plausibly pled, and emphasize that, again, that the district court's approach of examining each statement in isolation wasn't proper. The likely impact from this is, I think, it might be easier for a brand to survive a motion to dismiss in this kind of situation, just because the brand doesn't have to focus just on the skinny label, but can sort of rely on the totality of circumstances to allege a case of induced infringement. And so with that, I'll turn the next case over to you, Brett.
Great. Thanks, Andy. So the next case we're going to discuss is another patent case from the Federal Circuit called Edwards Life Sciences Corp. Versus Merrill Life Sciences. The top line takeaway from this case involves the Patent Act's so-called safe harbor provision, which basically says so long as a use is reasonably related to the development of information for FDA approval, the intent of the parties and non-FDA approval of other uses are irrelevant to application of the safe harbor provision. Let's go to the next slide. Here are the facts. Merrill, the defendant in the case, is an India-based medical device company who imported into the United States a couple of allegedly infringing medical devices. These devices were never shown or used, nor were they sold or offered to sell. And those are typically the acts of infringement under 35 U.S.C. 271. I do want to read something from the court's opinion. This is another opinion by Judge Stoll on the Federal Circuit. So she was pretty prolific on the significant cases in 2024. The medical devices at issue in this case were something called transcatheter heart valves. And this involved this company, Merrill, transporting 2 of these transcatheter heart valve devices to San Francisco for the 2019 Transcatheter Cardiovascular Therapeutics Conference. And this is what Judge Stoll says in her opinion. On September 24th, 2019, Nilay Ladd, a Merrill employee, traveled to San Francisco to attend this conference. He carried 2 sample MyVal systems with him on his flight to San Francisco International Airport. The 2 samples were in a bag accompanied by a written declaration stating, quote, "This is to inform you that the demo samples carried by Mr. Nilay Ladd is for the demonstration purposes only. It consists of demo samples of medical devices. They have no commercial value and hence it is not used for any commercial sale purpose." That's right from the opinion. That label was on the devices when they came into the United States. So Edwards, a competitor of Merrill, had patents that they thought were infringed by these transcatheter heart valve devices. So they sued Merrill for infringement. In response, Merrill invoked the safe harbor provision of the Patent Act, and the district court granted summary judgment of non-infringement, holding that Merrill's importation of these 2 devices fell within the safe harbor provision since Merrill's actions were reasonably related to developing information for an FDA approval process. Now, the case generated a majority opinion and a dissent, and Judge Lurie dissented. As I mentioned, Judge Stoll wrote the majority opinion. We have on the top of the screen the actual language of the safe harbor provision. It reads, "It shall not be an act of infringement to make, use, offer to sell, or sell within the United States or import into the United States a patented invention solely for uses reasonably related to the development and submission of information under a federal law which regulates the manufacture, use, or sale of drugs." That's 271E1, the so-called safe harbor provision. The majority ruled that solely modifies for uses. Thus, the safe harbor provision covers acts or uses that bear a reasonable relationship to the development and submission of information to the FDA. And on the facts of this case, that conference in San Francisco, the evidence showed was related to the FDA approval process. And then the dissent, Judge Lurie, would have applied a narrower construction of the safe harbor provision. Judge Lurie argued that solely creates a safe harbor only for uses, sales, importations that are solely for the development of information for the FDA, insisting that the purpose of the use and a party's intent is relevant to the safe harbor analysis. You can go to the next slide. So this obviously broadens the majority's interpretation is a broader application of the safe harbor provision than the dissent would have provided. And so Edwards, the party on the losing end, has requested en banc review. And if rehearing is not granted, Edwards will most likely appeal to the Supreme Court. There was actually a report out just this morning about a discussion of this case at a recent conference where Supreme Court review was urged. So the likely impact, if this decision stands, it favors potential infringers. A potential infringer may fall within or invoke the Patent Act safe harbor, so long as it can demonstrate that the activities, allegedly infringing activities, are reasonably related to the development and submission of information for FDA approval, such as importing into the United States some devices to show them off at a conference. We can go to the next slide, Andy, and I think it's back to you.
Yep, thanks, Brett. So the next case, we're turning to copyright law for a bit, and this is one where a decision that did come down from the Supreme Court. This is Warner Chappell Music Inc. versus Neely, and at the highest level, what the case talks about is where the discovery rule applies in terms of when a copyright infringement claim accrues. The copyright plaintiff may seek damages beyond the 3-year statutory limit that's set in the Copyright Act. The Copyright Act, so the provision there, Section 507B, says that no action shall be maintained under the provisions of this title unless it is commenced within 3 years after the claim accrued. The Supreme Court's decision notes that there's a couple of different views as to when the claim accrues. One is when the infringement actually happened, and the other is when a plaintiff discovers or should have reasonably discovered the infringement, which is the what's called the discovery rule. Interestingly enough, the Supreme Court here did not decide one way or the other which is the proper test for when a copyright claim accrues. Its decision is based on the assumption that the discovery rule does apply because that was not challenged at the 11th Circuit below. And so facts here, Neely and Butler formed Music Specialist Inc. And made some music a while back. Neely did a couple of prison stints from, I believe, 2008 to 2015, something around there. And so while unbeknownst to him, Butler started granting licenses for MSI's musical works to Warner Chappell. And so in 2018, when a couple years after Neely alleges that he learned that Warner Chappell was infringing his copyright, he brought a lawsuit against Warner Chappell for copyright infringement. And the infringing acts date back to 2008, again, while he was in prison. And so he alleges, again, that he didn't learn of the infringing conduct until 2016, which is less than 3 years before he sued. So the discovery rule could apply. The Supreme Court here, again, assumed that the discovery rule applies for the accrual of a copyright infringement claim and held that there is no 3-year limit on damages when you are applying the discovery rule for a copyright plaintiff to bring a claim for acts that occurred more than 3 years before the filing of the lawsuit. The 3-year damages bar that was applied by the district court, but not by the 11th Circuit in the discovery rule context, would essentially, what the Supreme Court said, gut or silently eliminate the discovery rule. In other words, if you with the discovery rule, you are allowed to bring claims for infringement that occurred outside of 3 years. But if you then have a damages rule saying that you can't claim damages for acts beyond 3 years, then the application of the discovery rule really makes no sense. the Supreme Court clarified it's a Petrella decision that so there was another case that where the Second Circuit came out differently and said that the when the discovery rule applies, the 3-year damages bar still limits the recovery that the plaintiff can recover. So the Supreme Court was resolving this difference between the Second Circuit and the 11th Circuit, and the Second Circuit, in coming out the other way, had relied on the Supreme Court's decision in Petrella, and the court basically said that the Second Circuit took that decision out of context, and the court statement in Petrella that the Copyright Act allows plaintiffs to gain retrospective relief running only 3 years back from the filing of a lawsuit was made specifically in the context of a plaintiff who could not use the discovery rule. So this opens up potential damages for copyright infringers beyond the 3 years that's set forth in the statute, assuming that the discovery rule is properly applied to the plaintiff. And also, again, just to reiterate, the Supreme Court did not make a final decision here as to whether the discovery rule is even proper in terms of determining when a copyright claim accrues. In the dissent, actually, there's the dissent in the Warner Chappell case, and they mentioned that typically the discovery rule applies in the context of fraud or concealment, and there was not really any that didn't apply in this situation, just because the plaintiff was in prison, but there wasn't any active any affirmative acts by Warner Chappell to try to hide this from him. So it may be that this decision ultimately may not have any effect, depending on what courts do with respect to the discovery rule moving forward. And with that, we have another set of copyright cases. I'll turn it over to you, Brett.
Great, thanks, Andy. So we are doing the 2024 year in review, but we're going to take a step back all the way to 2023 for just a moment to set the stage for the next couple of cases we're going to discuss. In 2023, the United States Supreme Court decided Andy Warhol Foundation for the Visual Arts versus Goldsmith. And this case concerned the fair use defense. And fair use defense is very, very common in copyright infringement cases. Andy and I have litigated multiple copyright cases where this defense was raised. And in the U.S. Supreme Court's 2023 case, in the Andy Warhol Foundation case, the court tightened up fair use, narrowed it, limited it to an extent. The case involved these famous images of prints that Andy Warhol created, so-called orange prints. Lynn Goldsmith was a famous rock photographer, may still be alive. Maybe Miss Goldsmith is a famous rock photographer. Took these pictures of Prince in his early years, and Andy Warhol created these famous works of art, around 12 or 13 prints, including orange print. And then the Andy Warhol Foundation licensed orange prints to a magazine, Condé Nast, the big magazine publisher, for use in publication. Goldsmith sued the Andy Warhol Foundation for copyright infringement, and the Andy Warhol Foundation invoked fair use. And just as a refresher for folks, there are 4 fair use factors. It's a 4-factor test. The first is the purpose and character of the use. And that turns on 2 sub-factors. One is whether the allegedly infringing use is transformative or not. And the second sub-factor is whether the allegedly infringing use is of a commercial nature or not. And then the second factor is the nature of the copyrighted work. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Imagine something like a lengthy book, Ulysses. A small excerpt of that is more likely to be considered fair use than copying of the whole book. The fourth factor, effect of the use on the potential value of the copyrighted work. So the Andy Warhol Foundation versus Goldsmith case focused just on the first factor. And in Goldsmith, the Supreme Court held that the first factor did not favor the Andy Warhol Foundation. And the Supreme Court said if an original work and a secondary use share the same or highly similar purposes, and the secondary use is of a commercial nature, the first factor of the fair use defense to copyright infringement is likely to weigh against fair use. And in this particular case, the court said, well, Goldsmith's original photograph shared substantially the same purpose because both her photograph and Andy Warhol's piece of art were portraits of Prince used to depict Prince in magazine stories about Prince. And then it was commercial in nature because the Andy Warhol Foundation licensed it to Condé Nast for $10,000. So in this case from 2023, the Supreme Court tightened the test for fair use and applied it to the specific facts of the case and said factor one tips against fair use. So now we're going to talk about a couple of cases in 2024, actually, seeing how the courts are interpreting and applying the Warhol Foundation versus Goldsmith case. So the first one we're going to discuss is Philpott versus the Independent Journal Review. And this is a Fourth Circuit case from 2024 that held when both the original and secondary uses of a copyrighted photo serve to depict the photographed figure, they share substantially the same purpose and there is no transformative use. Let's go to the next slide. So the facts of this case involved a photograph that Philpott took of the musician Ted Nugent. So that was the photo. And then a publication called the Independent Journal Review used that photo in an online article and failed to either pay a license fee or provide the required attribution. Interesting tidbit, the article from the Independent Journal Review that used this photo was entitled 15 Signs Your Daddy Was a Conservative. And under sign number 5, it said, he hearts the Nuge, which was a reference to Ted Nugent. And of course, he's a fairly outspoken conservative. So that was the use that was made of the photo by the Independent Journal Review. Philpott sued the IJR for copyright infringement. IJR argued fair use. The district court held for IJR, and Philpott appealed, and the Federal Circuit reversed. And the Federal Circuit held there was no fair use defense because applying factor one, as it was tightened up by the Supreme Court in the Goldsmith case, the Fourth Circuit held the secondary use of the photo by IJR was not transformative. This is a quote from the case here. As in Warhol, Philpott took the photo to capture the portrait of Nugent, and IJR used the photo to depict the musician. Accordingly, the two uses shared substantially the same purpose. Let's go to the next slide. On the left is the original photo by Philpott, and on the right is IJR's use of the photo. And this is another quote from the Fourth Circuit's opinion. Indeed, IJR has less of a case for transformative use than the Andy Warhol Foundation did in Warhol. Unlike the orange dubbing in that case, IJR did not alter or add new expression to the Nugent photo beyond cropping the negative space, as you can see here. Let's go to the next slide, please. And I turn it over to you, Andy.
Thank you, Brett. So sticking with the same theme of transformative use after the Warhol decision, we have a decision in August Image versus Gerard Entertainment and Media out of the Southern District of New York. And just a quick summary of the case is that a copyrighted photo included in a social media post is transformative if the purpose is to report or comment on the post, as opposed to the photo itself. And so for some background facts here, August Image licensed the photo you see on the right there of the Friends cast and sued for copyright infringement of that photo. David Schwimmer, who is a member of the Friends cast, had used the photograph as part of an Instagram post and captioned it with "It's happening." And the defendants, Gerard Entertainment, the owner of the website, used that screenshot of David Schwimmer's post in an article titled "Can Friends Reboot Count on Aging Fans to Rekindle Love of TV Show?" Gerard raised a fair use defense in the case, and the district court upheld the fair use defense there. The first bullet point notes that publishing a copyrighted photograph included in a social media post is transformative when the purpose is to report or comment on the post, which is itself the subject of the story. So the subject of the defendant's website was more the social media post provided by David Schwimmer saying "it's happening," as opposed to the photo that had been taken that was owned by August Image. So as the court notes, the article's focus was on the fact that Schwimmer's Instagram post of the photograph with caption "It's happening" suggested that the popular sitcom would return. The inclusion of the photograph was incidental and wholly distinct from the purpose for which the photograph was taken. So the court found that that was transformative and thus fair use. The case was decided this year, and so it's on appeal to the Second Circuit. We have, I think, one more fair use case for you, Brett.
Great, thanks, Andy. Yeah, so now we've discussed two post Andy Warhol versus Goldsmith cases that rejected fair use. And we're going to talk about a third. And so this is a little bit of a trend. And as Andy noted, the prior case is up on appeal to the Second Circuit. And I'm going to talk next about a 10th Circuit case from this year called White Monkey Productions versus Netflix, where once again, applying the Supreme Court's decision from last year, here the 10th Circuit rejected a fair use defense. But in this case, the 10th Circuit's opinion that I'm going to discuss and summarize here now has actually been vacated because the full 10th Circuit has granted en banc and panel rehearing. Oral arguments were heard en banc in July of this year, and the en banc panel's decision has not yet come down. So this case involved a plaintiff. His name is Timothy Seppi, who was a photographer and media person working with the guy pictured here, Joe Exotic. And some listeners might recall the popular Netflix series right around the time of the COVID-19 pandemic involving Joe Exotic and his zoo in Oklahoma with these big cats like the one pictured here. Timothy Seppi was a photographer, and he shot a lot of video around the zoo. And this case involved one of his videos in particular he videoed the funeral of Joe Exotic's partner, Travis Maldonado. And the video itself was about 20 minutes long, and Seppi registered the copyright on that video. And Netflix, in the popular series, played about a minute of that video. And so Seppi sued, alleging Netflix used his copy. Well, Seppi is White Monkey Productions. That's his LLC. And White Monkey Productions LLC sued Netflix, claiming copyright infringement. The district court granted summary judgment in favor of Netflix and held that using that one video constituted fair use. And the 10th Circuit reversed that summary judgment victory for Netflix in the light of the Supreme Court's recent guidance in Warhol. In other words, applying the Supreme Court's 2023 case. And what the 10th Circuit said is, quote, Warhol clarified that Campbell, prior fair use case, cannot be read to mean that any use that adds some new expression, meaning, or message weighs in favor of fair use under the first factor, the one that we've been focusing on for the past few minutes. 10th Circuit held no fair use. Instead, the use must involve commentary on the original work itself. Here, Netflix use did not comment on Mr. Seppi's video. Instead, Netflix used the video to target a character in the composition. And according to the 10th Circuit, Warhol has deemed such a use to be not sufficiently transformative under that first factor. Netflix used the video to comment on Joe Exotic, specifically, quote, to illustrate Mr. Exotic's purported megalomania, even in the face of tragedy. But according to the 10th Circuit, this only provided a historical reference point in Mr. Exotic's life and commented on his showmanship. It was not a transformative use of the copyrighted work. And on that basis, the 10th Circuit held that the first factor tilted against the fair use defense. As mentioned, the 10th Circuit vacated this panel decision and granted en banc panel rehearing. Oral arguments were held in July, and we're waiting on the opinion from the full 10th Circuit. So I think we're going to move away from copyright and fair use, and I'm going to turn it back over to you, Andy.
That's right. Now we're going to turn to trade secret. Then the Motorola Solutions versus Hytera Communications case. This case is coming out of the 7th Circuit and has to deal with the Defend Trade Secrets Act, the federal trade secret statute. And this decision, the court decided as a matter of first impression that the DTSA allows parties to sue for trade secret misappropriation occurring worldwide if there can be shown that an act in furtherance of the trade secret misappropriation occurred in the United States. So some background, Motorola accused Hytera of stealing trade secrets to develop competing two-way radios. You can see a picture of that, Hytera's radio on the right. Hytera was alleged to have poached Motorola engineers in Malaysia and had them download thousands of confidential files, including trade secrets, before leaving Motorola. And using that technology, the Solem technology, Hytera launched a line of radios that were functionally indistinguishable from Motorola's and sold them in the US and abroad. After trial, a jury, so there was a copyright infringement claim as well as a trade secret claim. We're talking here about the trade secret claim. Jury found Hytera liable for both trade secret misappropriation and copyright infringement. And for the trade secret misappropriation, awarded damages of about $400 million, which included over $200 million in punitive damages. On appeal, there was no real issue. The appeal did not cover whether did not challenge whether Hytera had in fact performed all of the acts that the jury found it had committed, but instead challenged whether the DTSA could be applied extraterritorially for acts outside of the United States. And so, as I mentioned before, the court noted that whether the DTSA rebuts the presumption against extraterritoriality is a question of first impression for our circuit, and as far as we can tell, for any circuit. And so there's a RJR Nabisco case that that sets forth a two-part test for extraterritoriality. At first, taking a step back, generally for statutes enacted by Congress, there's a presumption against extraterritoriality that the laws will be applied outside of the United States. So the first part of that test is to determine whether the presumption against that has been rebutted. That is, whether the statute gives a clear affirmative indication that Congress intended it to apply extraterritorially. And if so, then the court needs to determine the scope of the statute and how broadly that can apply. And so here the district court and the 10th Circuit noted that there in the private right of action section for the DTSA, there's no express reference to extraterritorial conduct, but what was important to the 10th Circuit's decision was that I think it's the 7th Circuit's decision is that the DTSA's predecessor, which was a criminal statute, the DTSA created a private right of action for trade secret misappropriation. So the predecessor statute did allow for conduct occurring outside of the United States. And Congress also made several references to extraterritorial conduct when it enacted the DTSA. And so there was a question of whether the whether the extraterritorial application from the predecessor statute limited that to only criminal matters, or whether it should also broadly apply to the private right of action in the DTSA as well. And the 7th Circuit determined that taken together with the statements made by Congress, it is clear that Congress was concerned with actions taking place outside of the United States in relation to the misappropriation of U.S. trade secrets when it passed the DTSA. And so with this decision, at least in the 7th Circuit, the DTSA allows parties to sue for trade secret misappropriation occurring anywhere in the U.S. or anywhere in the world, excuse me, if an act in furtherance of the alleged misappropriation occurred in the U.S. So this obviously increases the potential damages that might be available to a trade secret plaintiff, and also gives greater incentive to bring claims under the federal DTSA statute. It's worth noting here, just doing a comparison with the Patent Act's Section 271G, which is infringement by importation. That portion of the statute states, whoever without authority imports into the U.S. or offers to sell, sells or uses within the U.S. a product which is made by a process patented in the U.S. shall be liable as an infringer. So basically saying if you make something outside of the U.S. and import it protected by a process patent, that's still an active infringement. Prior to 271G, companies were able to escape patent infringement by making products overseas and then importing them into the U.S. I guess one point of distinction here is that 271G has been deemed not an extraterritorial application of U.S. patent law, but it's focusing on the act of importing into the U.S. as being the act of infringement. And so now we're going to turn to trademark law, which as Brett mentioned earlier, there was a Supreme Court decision coming out of for trademark law this year.
Thanks, Andy. And I just want to say that I think the Motorola versus Hytera case that you just summarized is a really significant case, especially for us practitioners, probably the most significant case that we're going to talk about. By contrast, this case, although it comes from the United States Supreme Court, I think is actually not such a significant case. So I'll go a little bit more quickly here. This is Vidal versus Elster. And in this case, the U.S. Supreme Court held that the so-called names clause, which basically prohibits registering a trademark that comprises someone's name, does not violate the First Amendment. So this guy, Elster, tried to register the mark Trump too small. You can see it here on the shirt. And some of you might recall that this was something that came up in the 2016 presidential election. The trademark office rejected the application applying the names clause, and Elster challenged that rejection, arguing it violated his First Amendment right to free speech. And the Federal Circuit accepted that argument and struck down the names clause, which has been around for a very long time, on First Amendment grounds. And if we can go to the next slide, the U.S. Supreme Court, in a decision written by Justice Thomas, reversed and held that the names clause does not violate the First Amendment. Folks familiar with Justice Thomas won't be surprised to know that the opinion cites historical precedent supporting the name clause. He goes back to the origins of the Trademark Act. And based on that, he rules, even though this is a content-based restriction, which gets subject to some heightened scrutiny under First Amendment principles normally, this is a content-based but viewpoint-neutral provision of the Trademark Act. And he finds that because it is viewpoint-neutral, even though it is content-based, it does not violate the First Amendment. The opinion says, and this is a direct quote, this decision is narrow, and the historical approach that saved the names clause may not apply to all future cases. Let's go to the next case, and I turn it back over to Andy.
Great, and we're turning back to patent law. It's a case before the Federal Circuit called Brumfield v. IPG. There was a number of issues in this case, but what was particularly important here was whether the expert could claim foreign damages where there was a causal relationship that was shown. The district court had prevented the damage expert from providing that testimony at trial because the district court was unwilling to say. So take a step back. There are a couple of cases. There's a power integrations case from the Federal Circuit that states that even after establishing a domestic infringing act, a patentee could not recover for worldwide sales on the theory that those sales were the direct foreseeable result of the domestic infringement. However, subsequently, there's a Western GCO Supreme Court decision that stated that allowed for recovery of damages for foreign conduct if there was causation demonstrated. The Federal Circuit in Brumfield expressly said that Western GCO supersedes the power integrations decision from the Federal Circuit, and that a party may recover foreign damages if it can show a causal relationship between the foreign conduct and the infringing acts. So it may be a little bit easier for plaintiffs to seek foreign damages, but it's unclear at this point what level of causal relationship needs to be shown because the Supreme Court, excuse me, did not address that issue in Western GECO in that decision. And so, sticking with patent law, I'll turn it over to you, Brett.
Thanks, Andy. Next, we're going to discuss Love and Care Limited versus Lorraine. This is a Federal Circuit case from earlier this year, written by Judge Stark, former district judge in Delaware. And this case involved the inequitable conduct defense. And it broadened or loosened a bit the defense, making it a little bit easier maybe to establish the inequitable conduct defense. In this case involved a dining mat for toddlers and a patent for such a thing, and a challenge to the validity of the patent on, among other grounds, inequitable conduct. And the district court rejected the inequitable conduct defense, which in our experience is fairly common. It's a tough defense to prove. And the Federal Circuit reversed, and the Federal Circuit held that materiality of statements made to the Patent Office, kinds of statements that could lead to inequitable conduct, may be proven by showing either that a misrepresentation impacted the PTO's patentability decision or egregious affirmative misconduct alone. And intent, which is another requirement of the inequitable conduct defense, an intent to mislead the PTO, could be shown by individual acts in isolation or examining a patent owner's acts in the aggregate. So, and in this case, there was a piece of prior art that the applicant actually brought to the attention of the Patent Office, which prior to Love and Care and in the district court's opinion, the fact that it was disclosed to the Patent Office defeated the inequitable conduct defense. But the allegation in this case was that even though the applicant provided the prior art to the Patent Office, it withheld other prior art related to that prior art, and it allegedly affirmatively misled the Patent Office regarding the features of the prior art mat. So the likely impact of this case likely broadens the inequitable conduct defense, likely provides more ways to demonstrate materiality and intent. Accused infringers may be more likely to plead and try to prove this defense. We may see an uptick in the inequitable conduct defense. But it's a little unclear in the light of this decision what the nature of the causal relationship must be between the acts giving rise to the defense and how that might have misled the examiner into issuing the patent, and whether proximate cause will be required. Andy, I'll pass it back to you. And I think what we have one more case, and then we're going to talk about the PTO.
I think we're running up on time, so I'm just gonna flag briefly. This is the AI Visualize v. Nuance Communications case. It's another Federal Circuit case that talks about subject matter eligibility under Section 101. There are a number of these cases every year before the Federal Circuit, applying the Supreme Court's two-step test set forth in Alice, and that's basically step one, determining whether a patent claim is directed to an abstract idea, so patent eligible subject matter, and then at step two, determining whether there's a sufficient transformation to take the claim beyond the abstract idea to make it patentable subject matter. So AI Visualize was a case that was recently decided, and there were another couple of cases. You can see them in our slides. There was a Chewy versus IBM, and the Brumfeld decision also had some 101 issues as well. And so just generally some considerations to take away from these 101 cases is drafting claims in a manner that would support a technical solution to a technical problem. That's not always easy to do. There's always plenty of litigation around that issue. And then making sure to the extent possible that any sort of unconventional or non-routine aspects of how something is done is appears in the claims. Like that, the how is very important in the context of 101. And so I want to give you some time to talk about the AI, because AI is very hot. Is a very hot topic these days.
Thanks, Andy. Yeah, and it wouldn't be a year in review in IP case law if we didn't touch on Alice and some of the cases under Alice that continues to roil up the IP bar. All right, last topic we're going to discuss is the PTO's recent guidance on use of AI in patentable inventions. The backdrop and the context here is a couple of years ago, the Federal Circuit held in Thaler versus Vidal that patents identifying a device, like an AI device, as the inventor are not patentable. And in the wake of that, we got an executive order from President Biden charging the PTO to formulate some guidance on AI and inventorship that led to these guidelines coming out of the Patent Office. This is very similar to what the Patent Office did a number of years ago following Alice, actually, the last case we discussed, where they provided some guidance for patent examiners. We're talking here about patent prosecution now, and this is guidance for applicants and examiners examining patent applications that will be incorporated into something called the MPEP, which is the book that guides patent examiners. Key takeaways from this guidance: first, AI-assisted inventions may be patentable. They're evaluated under the same criteria as other technologies. The use of AI tools in developing technologies does not alone prevent eligibility, as long as there is some significant human contribution. In other words, it can't just be AI. Key takeaway number two is, in order to overcome Alice-type rejections of inventions, applications claiming inventions where AI has been involved, you have to focus on the practical applications of the invention, write claims that provide a technical solution to a technical problem, and emphasize the improvements resulting from the invention. As they did with the Alice guidance years ago, the Patent Office has provided a number of examples to help guide practitioners. They're here 47 through 49. We won't get into those examples here, but these examples show how to apply the subject matter eligibility analysis of Alice to AI-related claims. And we can go to the next slide. More to come on particularly the USPTO's AI guidance. Just came out. We'll have to see how that gets applied in practice. And another thing that we are watching closely is this University of California versus Broad Institute case, which basically deals with a couple of interference proceedings over who actually invented the CRISPR-Cas9 gene editing system in eukaryotic cells, if I pronounce that correctly. And this is a highly anticipated decision, both because of the significance of the technology, the CRISPR-Cas9 technology, but also on a very hot topic in IP litigation more broadly, which is conception of an invention and what it means to be the first to conceive an invention. So this case has not been decided yet. Hopefully we're back next year talking about the ruling in this case as one of the more significant rulings of either 2025 or late 2024, as the case may be. So I think with that, that wraps up. Thank you very much for having us again. And we look forward to seeing you again next year.
So thank you both. Again, I know putting something like this together is a lot of work, but I know the attendees will appreciate it. So I appreciate your time.
Of course. Thanks, Wayne. We're happy to do it, and we'd love to see you again next year. So keep us on your list.
Take care.
Bye-bye.